Ladies and gentlemen, let me introduce myself. My name is Rahel Oktora, and today I will present my paper, Financial Exploitation by Spouse, a Crime in Private Space, an overview based on Indonesian legal system. I write this paper with my colleague, Fauzan Hanif Mujahidin. We are from Faculty of Law, Maranatha Christian University. Okay, in Indonesian legal system, we can classify the law as private law and public law. Private law is every regulation related with the private relation between citizens. There no intervention from the state. Different from the private law, in public law, there are intervention from the state because the state have to protect public interests. And now the problem is, what if financial exploitation take place in a marriage? Is it a crime, or it just something ordinary happen in marriage related to financial matter? In fact, Indonesian law has no clear regulation about it. So the problem identification in this paper are: first, can the act of financial exploitation in marriage by a spouse be categorized as criminal act? And the second, how does Indonesian legal system regulate the law enforcement of the cases financial exploitation in marriage in order to accommodate the protection of the victim? Okay, we will start our discussion from the marriage law in Indonesia, law number 1, year 1974. The social system and the legal system in Indonesia placement as the parties who have obligation to make money, and this is also mentioned in the provision Article 31, paragraph 3 of law number 1, year 1974 concerning marriage. Husband is the head of the family and wife as the housewife. Article 35, paragraph 1 mentioned that the husband has obligation to protect his wife and provide all things related to the necessities of marriage life in accordance with his abilities. And the second paragraph said that the wife shall take care of the household affair as best as possible. The formulation of this regulation gives the narrow view, namely the view that the economic problem in the household identical with the condition insufficient economic need, which is entirely the responsibility of husband, whereas in the reality, economic problem in marriage have a broader meaning. For example, women who use their husband's income irresponsibly or otherwise. So now we need to discuss whether the financial exploitation is only a financial problem or it also a legal problem, because it has not received the clear arrangement in Indonesian legal system nowadays. Financial exploitation is a financial violence. Because it related to violence, we need to discuss about it. Is it a criminal action or not? Indonesian marriage law recognizes the concept of unity or joint property in Article 36, paragraph 1 of the marriage law. It states that every property obtained during the marriage becomes joint property. The concept of share or joint property means that each party may take advantage of the property but must be in consent with the spouse. So from the private law point of view, we can say that to prevent financial exploitation by spouses in marriage, husband and wife may arrange a marriage agreement to separate the property. It may be legally executed by Indonesian legal system. So now we move to criminal law perspective on financial exploitation. Indonesia has law number 23, year 2004 on elimination of domestic violence. The law regulates about physical violence, mental violence, sexual violence, and domestic neglect. Domestic neglect related to the action of abandonment of wife by husband, abandonment of children by parents, or abandonment of family member. So the grammatical interpretation of financial exploitation does not meet this element. So as long as the Article 9 of domestic violence law do not provide the authentic interpretation whether financial exploitation is included in the article, so the action of financial exploitation cannot be penalized, although if we look, there is an element of loss to the victim, both materially and mentally, and the action is clearly contrary to the moral rules. This paper states that the use of terminology financial violence will be more suitable for use in domestic violence law. So, financial exploitation and domestic neglect becomes part of financial violence, which has broader or wider meaning. With the use of terminology financial violence, it becomes clear that the act should be punished. And now about the law enforcement. Criminal enforcement is certainly based on the existence of written law. Until now, law enforcement can be implemented against cases that meet the element of neglect as stipulated in Article 9 of the domestic violence law. So here is the recommendation first for the government or for the legislator to use the term financial violence in Indonesian domestic violence law. So it has a broader meaning, and the financial exploitation may be included in the regulation. For law enforcer to apply the rules based on legality principle to ensure the legal certainty, and for the community to be more aware of financial exploitation potentially done by a partner in marriage, and to study various prevention efforts. Okay, that's all I can present to you all right now. Thank you for your kind attention, and we can continue our session to question and answer session. One more time, thank you for your attention.